at St. Mark's. It's good to see old friends virtually and newer friends. Very, very glad to see all of you. I have been associated with St. Mark's in one way or another since 2003. So we're almost headed to a double sawbuck anniversary. And I'm very grateful to be invited tonight to talk about the constitutional law upon which LGBTQ rights sit in the United States today, and some of those challenges that have been emerging as we have seen the court progressively more conservative. I was going to say second guessing, but certainly looking twice at those rights as they've developed over the last many years. So yeah, if someone really has a question because they're going to be not understanding what's coming next, if they don't get that question out there to ask on a slide, feel free actually to just jump in and ask me to explain if it's not clear for you. I'm happy to do that, and I'm happy to take people's opinions. I know this is a trusted community. And I feel very privileged to be a part of it. And so I'm happy to have people interact with me. So that is the topic we're going to talk about tonight. And it does still appear, Alex, that I cannot move a slide. So if you could go to the next one, I'll just let you know when I'm done and ready to move the slides. Might be the best way for us to do this. So the case that is foundational to what becomes, or what we would today call, LGBTQ rights in constitutional law is Griswold v. Connecticut. And it was issued, as you can see, in 1965. And it's when the Supreme Court ruled that a state's ban, and in this case, Connecticut, on the use of contraceptives violated the right to marital privacy. So believe it or not, by Ripley in Connecticut, information about, in fact, as well as the products themselves, the use themselves, doctors working with women and men, but mostly women, was against Connecticut's law up until this ruling. And these Comstock laws came about at the end of the last century, meaning the late 19th century into the 20th century, and remained on the books all this time, even as people's social practices began to change. But finally, a case was brought forward and the Supreme Court had an opportunity to opine. And the main theory that captured people's sensibility about this ruling was, we don't want police in our bedrooms. And please note, it is for marital privacy. It only applied to married couples at this time. This case became the basis of a constitutional right to privacy. The term privacy is not in the Constitution, and privacy as a concept is as old as human societies. But in Western law and tradition, it always had functioned as a social norm and not a explicit legal concept until somewhat recently. And there were other cases coming about at this time concerning communications and electronic medium that in the 20s, for example, was found to be legal for law enforcement to tap a phone line without getting a warrant, will be overturned in the 1960s, 1967 to be precise, in a very important case, Katz versus the US. And there are other areas of privacy that in constitutional law are taking place around this theme. And so these norms that had been functioning in, let's say, middle and upper middle class society began to feel very offended by the emergence of a complex industrial society that intruded upon those social norms of a more simple and traditional agricultural life. And specifically, some technological advances truly troubled people. The Kodak camera was well known as one principal example that upper and middle class people objected to, particularly those who were newsworthy, so that with the rise of yellow journalism, people having their picture taken when they're in public and then it shows up on a newspaper or a magazine was found to be very violative of these social norms that people took seriously, but were not encoded in law. And so if we can go to the next slide, we can talk a little bit about how that concept began to be discussed in a legalistic way. Warren and Brandeis, of course, will be well known to us as a Supreme Court judge after 1890, when he and his law partner wrote a law review article that was entitled "The Right to Privacy." So there you get this concept of a right that is encoded in law, and then privacy, which is now moving from a social norm, very particularly held, very much believed in. The word is in our lexicon going all the way back to ancient Rome, at least, but was not articulated and enshrined with legal structure until this time. So this article introduced these notions. They did not specifically say where and how privacy should be encoded in the law. For example, they didn't talk about whether it should be a constitutional right, whether it's a criminal issue, a civil issue, or how it should be established, through the courts or through the Congress or through state legislatures. They just talked about the need to enshrine it with legal context and principles in order to give it the kind of support that before the industrial and technological disruptions existed very deeply in society for middle and upper middle class people. Again, think of slaves. They didn't have privacy. They created their own culture. Wonderful series that Henry Louis Gates Jr. has now. We can learn a lot about that, but they certainly had no privacy because of the social relations in slavery. And one can talk also about working class people and tenement housing and so forth and so on. I just wanted to give you a little touch of why I keep calling it a middle and upper middle class social concept that was very important to those people in those classes. Throughout the early part of the 20th century, a legal scholar by the name of Prosser writes in treatise that lawyers call restatements. So restatements are not law, but they are a way to either take existing law and restate it in a way that if you don't know anything about, the law of conspiracy, you can look it up in various books. You can go into existing cases. But another way, if you're just trying to understand what is conspiracy in US federal law, you can go to these restatements and at least get, a four-corner page understanding of it. And then you probably, depending on how you need to know the answers to those questions, go on and look in some of those other sources, because we do have a common law system that relies on precedent. But these restatements were also used as a way to advance law. And this is what this legal scholar Prosser did. He articulated 4 torts. Now, I didn't know that a tort was not something with ganache and flour or flourless cakes or whatever until I was in my 30s and went to law school. But sure enough, torts are civil. It's civil law, and they are claims that you can make against another person in the belief that they have violated some right that you have, your right to your privacy. So you can bring, there are criminal trespass laws, but you can also bring a civil law. If Ann Kiefer stepped on my property and I didn't want her to do that, I can bring a tort against her for that kind of activity. So that's what that kind of law is. And Prosser had 4 that he created. And so again, remember, this is theoretical. He is not writing the law. He's suggesting that the courts and or legislatures should make these concepts law. Intrusion upon seclusion, And again, these are all very case specific and fact specific. Public disclosure of private facts, false light publicity, and appropriation of name or likeness. You can only imagine how much our society has changed as you look at a couple of these to recognize how far our society has come in terms of social norms on the concept of privacy. The degree of intrusion that we exercise on ourselves, for example, when we post on social media, or people have posted about us that is not actionable, gives you a concept of how limited that kind of tort can be. Recently, there was a very good example of it, however, and let me just mention it so you get an idea. Does anyone remember the case a few years ago that was brought on this claim by Hulk Hogan, the worldwide wrestler guy, who a friend had persuaded to sleep with his wife, not Hulk Hogan's, but his wife, the friend, and then he videotaped it. And then they released it on Gawker, which was a website gossipy. And he actually prevailed in that case, that was found to be an intrusion upon seclusion. But that is one of the few cases where that has actually been successful in the courts. Public disclosure of private facts. I've been very public about my relationships, but say, for example, when Denise Yarborough, who was the rector at St. Mark's many years ago, and I were in a relationship together, if we had kept that very, very private, and who can I pick on now? And Stephanie, for I'm just picking on people, had put that in the Chronicle Express or something like that, it's possible that we could have brought a case against Stephanie for that. It's also very likely that we would have to show such an extraordinary degree of having kept that private. I wasn't there. We never announced ourselves together. You never saw us together. I'm in Ithaca. She's in Penn Yan. Never the twain met. Never did I meet any of the parishioners or anything like that. And then somehow, Stephanie, I don't know, let's make up some facts, is in Denise's office and sees something and it has my name on it. I'm making this up as I go along. It's possible to bring a case under those circumstances, but it's very, very, very unlikely for it to prevail. We would have to show such a high degree of trying to keep those facts private that it wouldn't work. Let me give you a real example. Do you guys remember the want-to-be assassin of Gerald Ford? Squeaky Fromm, the man who knocked the gun out of her hand as she was extending it in San Francisco, was gay. And the newspapers that reported on this event found out about that and disclosed it in the newspaper. He was so upset that he had never told his parents. He was an ex-Marine. That he killed himself. And so the family brought a case against the newspaper for having disclosed this private fact about him, and they were not successful. So, I mean, that gives you an idea of how extreme this has to be. I can't right now think of a case where it is successful. False light publicity, that could be a little bit more common, although usually it is held onto for people who already have some type of a public persona. I'm reading a very good book right now, and I have to open up my other device to get the name, but it's about disinformation. And it also traces the evolution of many of these extreme right groups, even more extreme than alt-right, and the various websites that trafficked in this material. And I saw something that I had never seen before, which was a take on the famous Obama caricature that went on many T-shirts and so forth. I'm sure that you know the one that I'm talking about. And now I'm about to say something that's very disturbing if someone wants to turn off their audio for a minute. I had never seen this before, but of course I'm reading this book because I'm teaching a course next semester on information policy. One of these extreme publications had him hung, which has got a long history in the United States of hanging African-American people. So technically, that would be a case that President Obama could bring. It's putting him in a false light for this kind of publicity. For 10,000 obvious reasons, he would not obviously do that. But that just comes as an example of how that could be. The appropriation of a name or likeness can also bleed over into the false light publicity. These are cases where a beautiful woman was put on the cover of a bag of flour, for example, and sold without her permission and without her getting any remuneration for her likeness being set there. This is used more recently, of course, with the way in which digital media can be manipulated and used, where you take someone like, I don't know, Leonardo DiCaprio, and then they redo something about him, and then that makes a lot of money. It's one thing if you're just putting something up, you can say it's satirical, you can say it's fair use, kinds of issues. Copyright bleeds over into this area as well. But sometimes, and if people are making money on it, examples are famous people whose faces wind up on billboards selling something that they didn't even have any relationship to. And in those cases, the person bringing the case is often very successful. So that just gives you an idea of some of the privacy issues that were emerging in legal thought about torts, because we're going to talk about something very different when we talk about the Constitution. Okay, Alex, we can go for it. So the judge in the Goldberg, in the Griswold case was named Goldberg, and he wrote, beginning his concept of privacy based on what also had been known in the law as fundamental rights. And some cases that were identified as embodying fundamental rights included parents being able to direct the education of their children, a fundamental right under the circumstances of that case. And I think that had to do with religious community and only having the children go up to a certain age. We have that living around us with Mennonite community, for example, and that was based on a case in the earlier part of the 20th century. Learning languages in schools during the First World War, in a school in the Midwest, German was prohibited to be taught because of the conflict with Germany. And so this came up as a Supreme Court case, and it was found to be a fundamental right to be able to learn a language. Body integrity. Castration was legal in some states. In Oklahoma, it was used. And curiously enough, not an Eighth Amendment issue, but as a fundamental right concept that was outlawed by the Supreme Court, castration. So Justice Goldberg then came up with this notion of a penumbra. Now, this concept has been ridiculed endlessly by people who disagree with these kinds of decisions, especially beginning with Roe. And so if you heard recently when in the Dobbs case, people were saying, oh, thank God we got rid of that Roe case. Well, they were really talking about the interpretation that was embedded in the Griswold case, 73, 8 years before Roe was issued by the Supreme Court. It is all founded on this notion that Goldberg wrote about, a penumbra of rights that he claims, and the majority of the judges believed equaled this concept of privacy that they're now encoding in the law. The First Amendment, free expression, The Third Amendment, no quartering of soldiers. That's kind of not anything that we have dealt with in American history much, except in the colonial time when the British did expect that kind of activity. The Fourth Amendment for warrantless search and seizure. The Fifth Amendment, self-incrimination, and then those rights, as it's been interpreted when you're arrested to remain silent and so forth. And then the Ninth Amendment, a lot of people, don't know what this means. It's sort of like after they created the Constitution, the question was, it's impossible that we got everything in here in terms of what is a right and an obligation. If we didn't write about it, does the Constitution mean that the government gets that right that we didn't articulate today but might come up in time? Or does that right go back to the people, and then through law or constitutional amendment, we would then encode that it is the government's purview? And the answer was the Ninth Amendment, to say unenumerated rights are left to the people. They are not to be assumed by the government. I would have added, had I authored this opinion, the Eighth Amendment about cruel and unjust punishment, because to me that seems, like at the very least an invasion of privacy. It often involves bodily harm. We talked about castration a moment ago. And so I would have even included the Eighth Amendment in this penumbra, but there it is. It's the First, Third, Fourth, Fifth, and Ninth. Okay, next slide, please. This notion, and again, you may have heard about these things very recently because of the Dobbs case, and so many people who objected either really to abortion, and they just objected then to any reason or explanation that the court historically had given as to why that was allowable by law, or some people who, I don't really know anyone who would say, well, it's not really about the result of Roe, but it's the reasoning that they gave that I object to. Some people will say that. I've yet to find anyone who doesn't also object to the reproductive right also. But let's think for a minute as if we are people who are just going to look at the reasoning and not talk about the result for a moment. The Griswold case revived a legal theory that has come up previously in American history called substantive due process. What is substantive due process? Okay, well, you probably have heard of due process, right? And its origins are in the Magna Carta, for heaven's sakes, going way the heck back in Anglo-American history. And it's in that case, it was, there has to be some way that people know what the crown is doing, that we can follow the process of the law. And it's a counterbalance, essentially, to arbitrary and capricious actions of any government, whether it's a monarchy or whether it's a democracy. In our Constitution, it's embedded in the 5th and 14th Amendments. You will see those words, due process, not substantive. You will see due process. So what's the substantive part? At these critical junctures of our history, some jurists have imputed into that concept of due process substance, legal principles of substance. For example, and now you'll see why this legal theory is very controversial. In the Dred Scott case of 1857, as we're leading up to the Civil War, the jurists had this case about a slave that was taken up into a free state. And did that mean that that slave was free or not? Now, the states had been divided between free and slave in the Compromise of 1820. And so one could argue very reasonably that if a slave was taken up into a free state, that slave should be freed automatically by law. But the court found otherwise and said that a property right embedded in the Fifth Amendment, because by the way, this is before the 14th Amendment, property rights embedded in the Fifth Amendment notion of due process have substance to them. And that substance is if the slave is the property of somebody in Alabama and they take them to Wisconsin, that is still their property right and they should be able to keep it. Now, I bet everyone in this conversation is not high on the concept of slavery. But look how this notion of substantive due process was used. You're adding the substance of this property right into the language of the Fifth Amendment due process in order to give it meaning in the law. Moving past the Civil War, New York State had a Bake Shop Act. And wait till you hear this one. It was a law restricting the number of hours that bakers worked to, are you ready for this? 16 hours. And it was thought to be an early labor law saying, you know, we're asking these people to work more than 16 hours. We should at least have a law in New York State that says they can't work consecutive hours more than 16. I mean, can you grasp that, the 16? But at any rate, goes to the Supreme Court in a case called Lochner, 1904 or 5. And the court, once again, does the same thing, although this time they talk about due process involved in contracts, and contracts are an aspect of property. And their argument was, we can overrule that state law because the higher order of the Constitution has this substance in due process that everyone has the right to contract for as long as they want to work. And so if a baker wants to contract with a worker or vice versa to work 20 hours consecutively, they should be able to do that. That's the substance of the due process in the Fifth and 14th Amendments, 14th Amendment having been passed in the late 1860s. And this was in the early 20th century. Is everyone getting an idea now of what the substantive due process is? So Griswold, this case that's important to us, 1965, many people would say the concept of a penumbra of rights is substantive due process because privacy is not in the Constitution. So we, the jurists, are imputing this substantive notion in due process that was found to be the constitutional reason to overrule state contraception laws. Why don't I take a quick break for a moment to just ask Alex if anyone has any questions, because a lot of what I'm going to talk about is ground in this concept, and I want to be sure if anyone has questions, this would be a good time to ask them.
So there was one question going back a couple of slides, I think. Do you see lawsuits coming out of new technology and very real looking fake videos of people saying things this is the deep fake thing, I guess.
Yeah, yes.
People saying things they wouldn't say or doing things they wouldn't do. Are there any lawsuits coming out about this yet?
They should be, but whether or not they're successful would depend on how the state law. So in those cases, those would be state laws that reflect those concepts that legal scholar Prosser established in his restatement. And it would all depend mostly, in those cases, it will depend on the harm. So if a terrible harm has found to have taken place as a result of, say, a deep fake, that would be much more likely to be successful than if Nancy Pelosi just didn't like that the Republican Democratic Committee, or whatever they're called, the Republican National Committee, or some Republican who did the deep fake of her slowing her speech down to make it seem as if she was intoxicated. Some of you all might remember that from a few years ago. That would not be successful, that case. These are people in public life. They should just get used to being picked on. And it's just too bad if you know, they feel as if their privacy has been violated. They never should have gone into public life in the first place. That's the way the thinking goes. I'll give you an example from my own experience. Some of the ridiculous things that were said about me by my opponent in the congressional campaign. believe me, and I felt like this is such a gross violation of my privacy, alluding to that I'm a drug addict, or that some of the things they claimed that I believed in about drugs and so forth. Across my mind, should I bring a lawsuit against them? It would be dismissed so quickly for the reasoning I just gave you about Nancy Pelosi, that of course it didn't go beyond a swirl in my own mind. So you have to have a very, very high bar, and often you have to have some terrible harm that has occurred. And you also probably should not be in public life. That right there is kind of, you have set aside your right to privacy by moving into public life. But I'll give you something that kind of cuts across. There was a woman many years ago, and it's apropos for our topic, who I'm going to say like Kentucky or someplace like that, went to a LGBTQ pride march. And there was a photograph taken of her by the newspaper. They weren't trying to get her specifically. It just happened she was there when they took this photograph representing the parade. In the paper, she loses her job. That state does not have LGBTQ employment protection like New York State does, for example. And actually, because Gorsuch agreed with a case that came forward in the Supreme Court 18 months ago or so, we actually have it federally in Title VII of the Civil Rights Act. She sued for a violation of her privacy. Nope, she did not prevail, because by her stepping out into public, by being at that parade, she had, in a sense, given up her right to privacy. I hope that answered the question pretty well.
Wow, that's chilling to think about, but
Yeah.
yes, that's the way it is. I think that did answer the question. That's the only question we have so far, so you can continue, and we'll maybe get a few more towards the end.
Very good. And I'm probably going to go a little bit more quickly now. It just was so important for you to understand this substantive due process that I was really bearing down on it. Let's go to the next slide. So the backlash, as I've alluded to, Griswold is this rejection of due process. It was terrible under slavery. It was terrible under trying to establish labor laws. Why would we want to resurrect it, even if it seems to be on the other side of the political spectrum? The constitutional amendments overruled slavery, of course, in the Dred Scott case, became overruled that way. And then in the 30s, if you've ever heard of this court packing concept that FDR had, because he was so mad that the court kept finding his New Deal legislation unconstitutional, that he wanted to pack the court, just like we've been talking about doing now. And the fear of that ultimately got one judge to change his mind. So he was starting then to get his New Deal legislation, for example, the Wagner Act, which is about labor, or the Social Security Act, which, is about federal pension. Those were found to be constitutional. And then he, dismissed this notion of packing the court because he's starting to get his way. But you hear the same kind of conversations now, because this Dobbs decision that just came out in May overrules the Griswold v. Connecticut case, at least insofar as it has to do with abortion. Let's go on. So there is no longer, because of this Dobbs case, a constitutional right to abortion, certainly one that was based on this notion of substantive due process of privacy. Now, we could talk all night about the spectrum of how judges interpret the law. So you may have heard about things such as literalism or originalist thinking, or do we do an interpretation because we're trying to understand what is the purpose of this law, or what was the intent of this law? It's a spectrum of interpretation. And largely out of Judge Scalia, he enshrined the notion of this originalist interpretation, and it's still being created, I guess you could say, but it has been used. Certainly Thomas uses it. Alito uses it. Coney Barrett, I think, is partial to it. Gorsuch would be like this, Kavanaugh would be like this, Roberts even a little bit less so, but I put them in the order of those that adhere to this notion. The notion itself is, would this be a right at the time the case, at the time that the law was enshrined? And this came up even just recently too with the Voting Rights Act. And I think Judge Jackson has been brilliant of talking about voting rights, as well as talking about what am I trying to say? Affirmative action in higher education, which of course is what I've done most of my life. So it's very interesting to me. And so many of the arguments now are saying, look, everything should be totally race neutral, never let race be a part of any decision. And she's saying, but that's not what the framers of the 14th Amendment meant when they created equal protection. They were doing it to reconstruct, in the Reconstruction era, the social relations between Black and white as this country ended the Civil War and was restructuring itself out of slavery. So it's very interesting. Originalism has been given this aura. As soon as you say, oh, well, this is an originalist interpretation, it makes you feel like all bets are off. Oh my gosh, well, if the founding fathers wouldn't have seen it that way, then there's no way that this could be law. But it's much more complicated, even using its own features as an interpretation. And I think Justice Jackson has been doing a brilliant job at kind of blasting this written in stone, God-given notion that has been accumulating since Scalia, talking about originalist interpretations. Okay, next slide. So so we all know now that in terms of abortion, the interpretation has been overruled. But now I want to take a step back and show you the cases that emerged out of Griswold based on this notion of substantive due process and a right to privacy. Okay. The first case that rested on it was one that gave the right to unmarried couples to learn about, have, or practice contraception. And that was in 1972. And then we get Roe versus Wade, based on this same concept that gives a constitutional right to an abortion. If people at some point want to talk a little bit more about the nature of that case and the justice who wrote the opinion, he was once an attorney for the Mayo Clinic, so he took a very medical approach to how to weigh the rights of the woman and the rights of the state. Although, note that he did rest the argument on this substantive due process notion of a right to privacy and not on equal protection for women. I'm just saying women because women are the ones who get the abortions. But it is known as a case that allows a constitutional right to have an abortion. And he did so on the trimester model, very medical model. In the beginning, the right to abortion is very strong. And by the end, the right to abortion is not so strong because the viability of the fetus imputes a legitimate concern that the state has in preserving that life. In all these years, since 73 to now, a lot of the fights have been about this. Viability became the essential dividing line. And in a subsequent case that we'll get to in a minute, we'll see that Justice O'Connor had a very interesting thought about this question of viability. So just note again, it's a right to privacy case, even though its constitutional roots lie in Griswold. Okay, next slide. Again, we're talking about cases grounded in this concept. Bowers v. Hardwick did not find that state laws against sodomy were unconstitutional. All right, I'll say that now the other way. a right to privacy was not found to exist between same-sex couple having sexual relations. So it was argued that there's a right to privacy in 1986. Teddy. Okay, so it was argued there's a right to same-sex privacy. And the court in 1986 said, no, there isn't, and allowed sodomy laws to stay on the books. Now, very unusually, that would be what we call stare decisis. Once a decision is made, the court should be very hesitant to overrule it. But we will see that this gets overruled pretty quickly. However, before that, a case about abortion comes in that's very important. It's the Casey versus Planned Parenthood case in 1992, where the test for abortion moves away from this trimester to that there can't be any undue burden for a woman wanting an abortion. So it addresses questions. Can we ask a woman to wait 12 hours? Can we ask a woman to see a video about the development of a fetus? Can we require parents for minors? Can we require a husband? Can we require a father if there's not a marriage? So states had all of these rules. And this case was really about those rules that were coming in from the states to limit abortion. And the new test about those rules was, is it an undue burden or not? Here, however, is where O'Connor makes the very keen observation where medical science and the law are on a collision course, because as neonatal care became greater and more precise, it's moving viability back. And the other very interesting thing that she did, but it was only in her reading of it, so it didn't fully enshrine the constitutional concept into law, is that from the 14th Amendment, which is about equal protection, that she suggested should be considered an alternative constitutional interpretation in support of reproductive rights of women. I mean, put a couple of asterisks around that. That is not what was discussed in this Dobbs case this past May. Okay, next slide, please. So now we get a very quick overruling. Lawrence v. Texas, I neglected to put a date, is 2003. So what that's not many years. Usually stare decisis would have not even allowed Lawrence v. Texas to be heard by the court, because they'd say, look, we just decided this in 1986. We're not going to just keep revisiting it. But they did, and they overruled Bowers v. Hardwick, and importantly established a right to privacy in same-sex sex. how much seashells, Sally sells, she sells. It's kind of hard to put that together with alliteration, but it overruled the sodomy laws in all the states and declared a constitutional right of privacy applied to same-sex relationships. And quite specifically, we are talking about same-sex sex. And Scalia, who dissented, deployed his originalist interpretation that legitimated the sodomy laws because he said, oh, well, this never would have been accepted by the framers. So there's no way that we should be accepting this now. And if you read his piece, he was very caustic, sarcastic, and he compares same-sex relations with bestiality. Curiously enough, though, he does presage same-sex marriage. And that is what we got finally in the Hodges case, was a constitutional right to same-sex marriage. And it was built on these same concepts of privacy in a relationship, privacy in same-sex sex. And now the right to privacy allows for same-sex marriage. Okay, next slide. And I think that was in 2015. I'm sorry I didn't put the number there. Maybe someone can look it up while we're chit-chatting. So now we're at Dobbs, May of this year. It tested the constitutionality of a Mississippi state law that prohibited abortion after 15 weeks. And there are a lot of little bullet points here. I don't want to take everyone's time. You can have these slides if you're interested and want to think about it more. But he overrules Roe and overrules the substantive due process concept of a right to privacy. He argues that abortion is different from the Griswold progeny because it involves the life of the fetus. And so then he said, look, we're not talking here about same-sex marriage. Don't worry about that. Because we're only talking about this right to privacy as being a fallacy of constitutional interpretation because of the facts. It involves the life of a fetus, which of course in his interpretation begins at conception. Linda Greenhouse, wonderful legal scholar now, used to be legal journalist. I actually had the same thought, but I read it very well articulated. And when she talked about this not being about privacy, but it's really a religion case because of that fundamental belief that life begins at conception. And of course, it is a conflict because not all religions have that same specific belief. There are some, obviously, and one held by Alito, and then other members of the court. But she thought we really should be looking at this case as about religion and not so much about privacy. It certainly recognizes O'Connor's warning about this collision course established by Blackmun's interpretation that puts viability of the fetus in conflict with the law. It did overrule Casey, so that 1992 case, insofar as it rested on Roe, but it did not address the equal protection line of interpretation that still kind of remains out there as another hook upon which one could make a very important legal argument. You have to have a hook. You can't just go into court. You can't go to the Supreme Court and say, I feel really bad about X, Y, or Z. And it should be different. You have to go in and have, first of all, it has to be about an existing law. And then if you want to change that law, if you want to do a penumbra and create a right to privacy, you have to have a hook. And that's what the substantive due process was. The hook was due process. So another hook that could be used is equal protection. And that's the language found in the 14th Amendment. Next slide, please. Thomas is the most conservative justice we have on the court today. Because, Alito was saying, look, I'm only talking about abortion because a life is involved. I'm not talking about same-sex marriage. Thomas wrote a concurrence. So he was part of the majority, but he wrote a concurrence to say, I'm not taking same-sex marriage off the table because he knows this line of cases that goes all the way back to Griswold. And he is saying, he said it explicitly, I'm not taking that off the table. And of course, he and Scalia were very, very close. And you've got Scalia in the Lawrence v. Texas case, presaging that there would be a constitutional right to same-sex marriage, which proved to be true. He died before that happened. And Thomas is saying, in that same thinking that Scalia would have had, I'm sure they would have agreed on this concurrence, that no, we're not taking that off. Now that we've tossed that interpretation, we can now begin to think about how to use it against some of these other ways in which it's been deployed to create rights for people. By the way, so would contraception be open to judicial curiosity and challenge as a result. So using that interpretation as a guide, Thomas would likely also have Coney Barrett, probably not, however, Gorsuch, Kavanaugh, or Roberts with him. That's just my prognostication. And it would have to be so fact specific to figure out how and why. Okay, next slide, please. I have mentioned this. This slide is devoted to a little more depth on it. We need that hook. Equal protection can work as a hook. Equal protection would very likely be attractive to Gorsuch, who I mentioned voted for LGBTQ employment protection. Kavanaugh, who was reported to have been amenable to Roberts' more moderate approach if Roberts had prevailed. And Roberts, who has always demonstrated more of an interest, not totally, but more of an interest to, he wanted to observe stare decisis. If I understand what commentators have said, he would have found the Mississippi law constitutional, 15 weeks, but he would not, if he were writing that opinion, he would not have overruled Roe, because he knows it really upsets the apple cart of all of these kinds of cases. On the other hand, equal protection would not be attractive to Coney Barrett, who, in contemplation of a religious disposition as dispositive, in other words, she leans on religion like Alito did in the decision that he wrote about the Dobbs, would have little respect for the unenumerated individual rights that are emergent in 14th Amendment equal protection jurisprudence. Next slide. And I can explain that if people want to know what I just said. Okay, so the political aftermath is after Roe. We've been watching Biden, who's tried to use administrative law to be supportive of women's rights to abortion. Let's see what happens. We saw what happened in the primaries. It seemed to be very positive for left of center and Democratic candidates, emphasizing the concern that they have about legal right to abortion. We'll see. Commentators are saying that's not so prominent now. It's crime and the economy that is really taking front and center, and the abortion thing has abated in some ways. We'll see. We'll see. State by state, just to be clear, Dobbs did not make abortion illegal in every state, but that decision allows the state law to take over. So you've got some states rushing to the bottom. Life begins at conception, no abortion whatsoever, no rape exception, no life of the mother exception, no viability of the fetus exception, nothing like that. And then you've got a state like New York and Governor Hochul, who has publicly announced that New York could be a sanctuary state for women who are seeking an abortion and live in a state that does not make it legal. So we'll have to watch what's happening here very, very closely, because should same-sex relationships and same-sex marriage be overturned by this court, we would want to at least be thinking through what is that going to mean on a state-by-state basis, and then how do we rebuild again. Okay, next slide. Although we should be pretty close to the end. There's been congressional action to legalize abortion nationally. It would fail if that vote were taken away. There's been congressional action to make abortion illegal nationally, and that vote would fail if it were taken today. I'll give you an example. In the district where I ran, 60% of people, and it is a red, ruby red district, 60% of people favored legal abortion. So, this is a complicated issue. I don't have the statistics for same-sex relationships or marriage similarly. Bills to legalize same-sex marriage was approved in the House. In other words, fearing that the court could overrule it, we're going now to Congress to see if we can keep those rights intact, but it's sitting before the Senate. It really makes these elections important as important can be. And I wanted to throw in one international perspective just as contrast. And it's so curious that a country that was so dedicatedly Catholic for so long took the issue not to its courts and not to its legislative body, but to the people in a referendum. And in both cases, same-sex marriage and abortion were put to popular vote referendum, and both passed. It's interesting that we're not doing that here in this country, and one might want to wonder why. That's the end of my presentation, so I'm going to end on asking what your thoughts are. Thank you.
Engaged. So this question, we've got two questions. Let's see. So first is the use of the abortion pill beyond the legal grasp of the current Supreme Court?
Well, it right now it is, but we will see if some interest groups don't, bring that in a state that has gone all the way to the bottom, as we say. I can imagine that there would be a group that might bring that as a violation. But that would then, yes, I mean, that would be based on the state law, of course.
And then the other
And
question.
the definition of abortion. I mean, it would be a fascinating case. It would
Yeah.
probably get pretty heavy into the medical science of it in order to figure it out, and then how that pairs up with any of these constitutional principles or not.
And we've started to hear a bit about that question of the definition of abortion, and as soon as sort of the blowback began, all of a sudden we have certain politicians who had been very clear previously about, well, abortion is what it is and that's all that it is, and we can't go making up new terminology or whatever. Suddenly they're saying, well, oh, that doesn't count as an abortion, or oh, if you're Herschel Walker it doesn't count, or whatever. I didn't say that with my librarian hat on. So the other question here, and I hope I'm reading this right, I think so, this person asks, and I think this is in reference to your slide showing sort of how the different conservative justices might wash out if certain arguments were made. Why wouldn't 3 of the conservative judges align themselves with Clarence Thomas? Was that what you were referring to? Okay. So can you say more about that little division, I guess?
Yeah. Well, first of all, Alito, at least he said, Alito was purported to have told, I can't even remember who it was, but he's purported to have told someone of some significant, Kennedy, Ted Kennedy, at the time of his coming before the Senate to be appointed to the bench, that he would protect Roe. Now, I saw that headline. I glanced over the article. I don't know the veracity of all the sources and so forth and so on. I'm making this point to say, he said in his argument, so a position that a court makes that's a decision is called the decision. And then everything else that they talk about is called dicta. The decision establishes the stare decisis. It is the rule. Dicta, there's no stare decisis that goes with dicta. So right now in the Dobbs decision, he said the other areas based on Griswold or based on Roe, they keep saying Roe, but it's really this Griswold case, which is curious. They don't want you, and I'll tell you why I think they do that, is because everyone talks about Roe. Very few people know that it's founded on the constitutional principle established in Griswold. And they don't want to bring up contraception because honestly, that would, put us back into the Stone Age in terms of reproductive medicine and rights and police in our bedrooms. It goes back to what really set people off finally to find a constitutional principle to overrule those state laws. And so he said in his decision, the dicta part, I'm not talking about same-sex marriage and I'm not talking about contraception. I'm only talking about abortion because it involves the life of he probably said child. I would have to go back and look at it. Why do I think these other justices? Well, because Thomas clearly said in his own opinion, supporting that decision, but in his own opinion and his dicta, he said, I'm not taking those other things off the table. But the other judges did not say that. But I also think that Coney Barrett, why do I say this? I mentioned Linda Greenhouse's interpretation that this case could really be understood as a religion case. That's very true for Coney Barrett's jurisprudence, that it's really religion that is guiding her interpretation of the law. So that's why I would put her over with Thomas in terms of these other issues, such as contraception and same-sex relationships. The other judges, I think that they are more traditional conservatives and not so completely dedicated to religion. Although I think certainly in the area of abortion they are, else they would have voted differently. But I don't think in other areas. Take Gorsuch and LGBTQ employment rights under Title VII of the Civil Rights Act. He voted for it, and it was his voting for it that got it to pass, even in this conservative court. So that's why I see that even though I know religion has an influence, and these are all Catholics. All of the judges who voted are either Catholic or an Episcopalian. Curiously enough. So I know it has influenced their thinking, but I don't think it has influenced their thinking as strongly as it has Alito. And then with the exception that he made, but very much so Coney Barrett and Justice Thomas is way off the other end of the spectrum. I know it's late and people don't want to hear me go on and on. There are a whole line of cases that are the foundation of our Voting Rights Acts and our Civil Rights Acts in the second half of the 20th century that are based on an interpretation given to the Commerce Clause that came out of the stitch in time that saved 9, that allowed for New Deal legislation to be found to be constitutional. Thomas has said he doesn't believe in that. He would revoke that too. So he's an extreme off the spectrum in his judicial interpretation. Any other questions?
Yeah, and someone else said that they had a question. They may be typing it into the chat right now, so we'll give them a couple more seconds to do that. But absolutely, don't sell yourself short about us, our listening, because the sense that I have from this room is everybody has been riveted to this. It's the most interesting legal presentation I think any of us have been to in quite a while. So
I've loved all of the presentations, Alex. I've been here for all of them. I so much wanted to talk, and maybe still will, to the guy who did the history of Rochester.
Oh yeah,
because there are a couple of bars that he did not mention.
We'll have to get you two together. We'll have you guys have a summit and flesh out all those details. But I'm not seeing that question coming in the chat. But Caroline, if you get it before we end here, we'll try to get it to Tracy, but you could also.
It'd be a lot easier to speak it.
Yeah.
Oh, okay, go ahead.
Yeah, go ahead.
First of all, I want to thank you so much for coming, and it's so nice to see you still have your same vivacious personality.
Thank you.
This is killing me. I am a Griswold. And
is that your maiden name?
We are all related. Back to the 1600s, I get a Griswold Family Association publication 4 times a year. Okay?
Wow.
So I am wondering who this Griswold is or was.
Yes. I can get you the sources, but I do remember, a lot of cases that go to the Supreme Court are kind of set up. I mean, Rosa Parks, there were many cases of people not giving up their seat, but they all didn't become Rosa Parks. So often organizations that are advocating in a direction to change the law and bring cases, they wait for a case that they think is the right case. Even the Dred Scott case was kind of a setup.
Interesting. Okay.
Yeah. The Griswold case was a setup. And I think Griswold was a doctor, but don't hold me to that. And, probably if you just went to Wikipedia, Carolyn, you would find the history of that. But it was, chosen by advocacy groups that wanted to get this issue before the Supreme Court.
Very interesting.
Yeah. And so, they really make them like the most sympathetic plaintiffs, and, they really take everything into consideration, because people can talk about, oh, we're just doing the law and it doesn't bear on baloney. It does. It does. I mean, it's human nature to try to see things contextually. I mean, it's part of the disagreement that many of us have against this originalist thinking. I mean, to be thinking that we have to have law that is stuck in the late 18th century is absurd. And
wait to share this with my siblings.
Yes, the Griswold sibling. But I think he was a doctor.
Interesting.
That had been found in violation of one of the Comstock laws because he was giving information about contraception to his patient.
Oh,
That's my thing.
did you tell us the year of it?
The case was 1965, but often it
Okay.
takes 2,
My
3, 4
lifetime.
years to get there. So the
Yeah.
original arrest could have happened in
Yeah.
the early 60s.
Oh, my lifetime. Okay. Thank
Yeah.
you so much.
You bet. Good to hear your voice.
Yeah.
Yeah. You know, Carolyn, all of these issues are very relevant to transgendered people because that will be the next judicial advocacy. And so that is why this is important. If a right to privacy is out now for good, and as you can see, it did kind of teeter on a checkered history. Dred Scott, Lochner, those aren't the best precedents because if you're just taking politics as a center and then you're going right to center or left to center, those were right of center cases. And now the abortion was a left to center. But if that is no longer going to be the interpretation, I predict that the interpretations will either reconstruct something around these fundamental rights. And I think that is very significant for transgender because of the one case I mentioned about castration. So in other words, people have a right to their bodily integrity. And by that, I mean, they can define it is what I'm trying to say.
Wow.
And they can do medically what they feel is necessary for their identity. Do you understand what I'm saying?
Oh, yeah.
Yeah. Okay. And then, but I think the big legal hook that is going to be what advocates are going to use constitutionally for the next 25 years at least is going to be equal protection and saying this is an equal right of my individual right. And so I think it will be not only relevant to same-sex relationships and marriage and contraception, but it's going to be very important in the cases that are going to be defining transgender rights nationally.
I saw a bumper sticker today in the JCC parking lot that said, "Vote like your rights depend upon it."
Yes,
Wow.
indeed.
That's the truth.
Yeah, indeed they do.
1 week from election day, that's a lesson for all of us. Absolutely.
Yeah.
If you haven't voted already, early voting is on. So go vote, everybody.
Right.
Tracy, we have one more kind of tongue-in-cheek question based on your response about our previous presenter and the bars.
Oh, yeah,
Craig asked if you're suggesting that we have to go on a bar crawl next. So maybe that'll be the next event.
Absolutely.
So get ready for that.
But because there has been so much acceptance, gay bars are not what they used to be, and they are few and far between.
Don't I know it?
Yeah, I mean that could be a conversation, for another time. But I had a great time in gay bars. So when gyms closed, and then there was a bar for women that your speaker, I definitely want to let him know about this because for women it was definitely there. It was called the Riv. And people who know Rochester and South Avenue as it's just beginning off of Main Street going south, it hits Broad. Am I making sense for anyone who knows? Well,
people are nodding.
Yeah, or not. And then it goes into a dip underneath the 490, or you can go on to 490, or there's this little street that goes down. There's a restaurant down there now called Vespers. And a little while ago, there was one called Nico, which I remember because that's my son's name. But there are buildings at the very end of that little block. And so you're about a block or so from Jiva, if that also rings a bell for people in that area. And this restaurant, the Riv, I'm sorry, man, that was where it was happening.
If only we could.
I'll leave that there.
Yeah. Well, thank you very much, Tracy. We so appreciate it.
Hey, a pleasure. Can't wait to see you all face to face. God love you all. Thank you.
Thank you. And thank you to everyone who attended. Thank you, everyone here in person.